Good morning, ladies and gentlemen. I'd like to welcome you to this morning's program on Health Law Update. I'm Laurel Evans. I'm a program planning lawyer for the Law Society's Continuing Education Department. I'd like to take this opportunity to thank today's faculty, most but not all of whom are here this morning, for taking their time to come to speak to you today and for preparing the papers that are in your materials. I'm going to assume that you know that this is a non-smoking facility and where the washrooms are and the telephones. I'd like you to, if you do have questions, you can ask at the front desk. Excuse me. We do have a message board facility which is located adjacent to the registration desk. I'd like you to check that at break, please. We do have the occasional secretary who calls in with a panic-stricken message for a lawyer. I'd like you to look through your materials this morning, and there's a gray form, which is an evaluation form, which I'd ask you to complete as you hear the program this morning. We take the evaluations very seriously. We read them all, and we rely upon them for assessing the programs that we present and for developing new programs. I'd like to make a note about Lori Stoltz's paper. It will be arriving. She is extremely pressed in terms of her commitments, and we're lucky to get her here this morning at all. But when we do get her paper, it will be forwarded directly to all of you. There is a note concerning a handout on Dr. Hebert's paper. He has a couple of corrections. If you would pick up the handout at the break, it will make a note of the corrections for Dr. Hebert's paper. I'd now like to take the opportunity to introduce you to the chair of today's program, Michael Fraleigh. Michael is a partner with McCarthy Tatro, and his practice is exclusively dedicated to the area of civil litigation with a significant emphasis in health law. His practice has provided a broad exposure to health law matters, including appearances in the courts before the Health Professions Boards, proceedings of the College of Physicians and Surgeons, at coroners' inquests, and other administrative tribunals. So without further ado, I'd like to take this chance to turn the program over to Michael. Thank you.
Thanks, Laurel. One only needs to read the newspaper, listen to the radio, surf the internet to appreciate significant changes to our healthcare system which occur daily. These changes are even more pronounced for those of us who are working in the system as lawyers, healthcare workers, regulators, or institutional administrators. I hazard to say that in years gone by, the business of delivering healthcare to the community was less complicated and less structured. We're today faced on a daily basis with new medical technology, more information on particular diseases or disease processes, funding difficulties, legislative intervention, and more ethical dilemma. There is a more knowledgeable public and a more demanding public, a public that will sue or complain if their expectations are not fulfilled, a public that will demand access to medical records, a public that will demand more care on the same terms as it is being provided today. And with this, health law too has become more involved. The legislative framework is getting more complicated. One only needs to look at the consent to treatment legislation to appreciate this. And all of this has made the practice of health law and those who have to work in the system more challenged, and the work certainly interesting. This morning, we are indeed fortunate to have an excellent panel of healthcare practitioners, and I will introduce each in turn, but these individuals have been instrumental in shaping the system that we have today, and that may make for some interesting questions a little bit later on. We'll take a break at about 10:40, and there will be ample opportunity at the end of the morning for questions. And let me start, if I might, by introducing our first speaker, Lori Stoltz. She obtained her LLB from Dalhousie University in 1987 and has been practicing since 1990. She's at Goodman & Carr and carries on a civil litigation practice with a health law emphasis. In addition to appearing in the courts and before administrative tribunals, Lori has developed a special interest in HIV and AIDS, and she was appointed by the Ontario Minister of Health to the Ontario AIDS Advisory Committee and sits as chair of the Health Protection Appeal Board. Lori will spend the next half hour or so updating us on the medicine and the law around the issues of HIV and AIDS. Lori?
I've been asked to touch on a number of areas in my presentation, and unfortunately, given the number of areas, the time won't permit me to deal with any of them in any depth. But by way of compensation for not having delivered my paper on time, to the extent that there is a question that you would like to see addressed in greater depth, I'd simply ask that you pass along that question to Laurel Evans, and I'd be happy to do so in my paper. I'm going to deal with three areas. First is to talk about the status of the blood litigation, the litigation surrounding the contamination of the blood supply. I'm then going to touch on the question of the right of healthcare workers to continue to practice. And thirdly, I'm going to look at or do a brief survey of the Health Protection and Promotion Act, which is an important piece of public health legislation in the context of HIV and AIDS, and I think important to know about, and perhaps isn't all that widely known or understood. First of all, to start with the status of the blood litigation, a person who has contracted HIV through blood or blood products during the period 1978 through 1985 has basically three options available. The first is litigation with a view to seeking compensation for those injuries. The first is litigation. The second is compensation through one or both of the no-fault compensation packages that have been developed by the governments. And the third is some combination of those. I'm going to talk first of all about the so-called no-fault compensation regimes established. As a practical matter, I thought it might be helpful for those in practice to have an understanding of what the basic elements are of both of those packages. The first one is the Extraordinary Assistance Plan, which was established by the federal government for recipients of blood and blood products who contracted HIV during the period 1978 through 1985. The package establishes, once entitlement is established, claimant has the right to receive annual payments over a 4-year period in the amount of $30,000 each. It is available to applicants who are either direct recipients or to their estates. There is no deadline for the application. That is, there's no time frame within which you must apply once you have discovered that you contracted HIV through the blood system. The documentation to apply for this package is very straightforward. There is a release that has to be signed. It's in relation to the federal government only, which leaves open to a person who signs on to this package the option of suing any other players within the blood system who might be responsible for the HIV infection. There is an authorization to the government to give access to any information they might need to confirm entitlement to the package. Once eligibility is established under the federal plan, claimants then have an opportunity to apply to receive payments pursuant to what is commonly called the provincial plan, or the MPTAP, the Multi-Provincial Territorial Assistance Program Agreement. This is an agreement that was established by a number of players in the blood system, most prominently the provinces, and insurers for other players such as hospitals, physicians, the Canadian Red Cross, pharmaceutical manufacturers of blood products used by hemophiliacs. What this agreement does is to set up an entitlement to a stream of payments that is slightly different than under the EAP. For a direct recipient, the entitlement is to payments of $30,000 per year as long as that person lives. If and when the person passes away, the entitlement to the annual $30,000 payment ceases, but a surviving spouse then has an entitlement to 5 annual payments in the amount of $20,000 each for a total of $100,000. Similarly, infants or dependents, persons who were dependents or met the definition of a dependent under the agreement at the time that the person was infected, is similarly entitled to a series of 5 payments of $4,000 each for a total of $20,000 per dependent. The release that is required in order to secure entitlement to this agreement is much, much broader than that which applies in the context of the federal plan, and certainly does seek off litigation as against any of those parties. There is also a certificate of independent legal advice clearly intended to shore up the release. There are circumstances in which a plaintiff might couple access to both compensation plans with litigation, and that is specifically in the situation of someone who has contracted HIV through blood or blood products and then transmitted that infection further to a spouse or a child. It is clear that even in the case of the MPTAP, although there are spousal benefits that flow and benefits that flow to the dependents, they are not intended to compensate the spouse and the dependents for a secondary HIV transmission. With respect to the question of how the courts, assuming that one did litigate and receive these payments, with respect to the question how the courts will deal with them in terms of double recovery, that's not yet sorted out. It has not yet been determined whether these are collateral benefits that should be deducted from a plaintiff's claim for damages as against the defendants. This argument was certainly raised in Pittman, but not decided because in the Pittman decision, Mr. Pittman was not successful in establishing that it was as a result of the negligence of the Red Cross that he had contracted his HIV infection. The claim was successful on other grounds, but not on that particular ground, so the court did not have to deal with the specific issue of how the collateral benefits should be treated. It seems to me that there is certainly a good argument that the payments flowing under the federal extraordinary assistance plan should not be deducted from damages that a plaintiff might otherwise receive on the grounds that the documentation leading to the announcement of that plan make it clear that they were considered payments that were ex gratia payments. They weren't payments intended to compensate for harm. That's a much more difficult case to make, I would submit, with respect to the multi-provincial territorial assistance plan agreement. With respect to the litigation itself, there was an attempt to certify a class action as against the Red Cross in February 1994. This was unsuccessful, and that was the case of Sutherland versus the Canadian Red Cross. It's not immediately apparent why this attempt to certify a class action was unsuccessful when a comparable attempt had been made and was successful in the context of breast implant litigation. The basis appears to be the multitude of disparate third-party claims that presented themselves in the context of the blood litigation. But if one compares that scenario with the breast implant scenario, there is the same chain of responsibility and the same players are conceivably involved. That is, the physicians who implanted the devices, the hospitals, the manufacturers, and at the furthest end of the chain, the federal government, which establishes and administers a regulatory regime to ensure the safety of the products. It seems to me that the distinction that may have been made, although it's not expressed in the court's reasons, is that in the case of the blood litigation, there was much wider distribution of the relevant knowledge. It's not a situation in which access to knowledge was tightly controlled by a single manufacturer, but information about the risk of AIDS associated with blood products was being widely disseminated throughout the medical and scientific communities. It was also pointed out in the reasons for judgment of Mr. Justice Montgomery that the plaintiff, who was being put forward as the representative plaintiff, was not truly a representative plaintiff. She was a woman who had contracted HIV through transfusion and was purporting to represent not just recipients of transfusion, but also recipients of blood products, hemophiliacs, and as a matter of fact, 75% of the persons in Ontario who have contracted HIV through blood or blood products are hemophiliacs. So she was felt not to well represent the class of plaintiffs. Certainly may be that a more focused attempt that concentrated on one group or the other might succeed. To my knowledge, none has yet been instituted or attempted. At present, there are fewer than 50 outstanding claims in relation to the contamination of the blood supply between 1978 and 1985. Most claimants accepted both of the packages and opted for the no-fault regime. The essence of the cases that remain, they have three prongs to them. The first is that the blood or blood products should not have been infected in the first place. The second is that the plaintiff should have been warned so that they could have avoided the administration of the blood products. And the third is that the plaintiffs should have been warned so that they could have minimized the risk of transmission to others. And there are a handful of cases that do raise issues of secondary transmission. In the context of the arguments that the blood product shouldn't have been infected in the first place, the cases made by transfusion recipients generally focus on donor screening efforts that ought to have been adopted by the Red Cross or made by the Red Cross, and the delay on the part of the Red Cross, or the alleged delay in the introduction of ELISA screening, which was the first specific test to test for the virus and remove it from the blood system. In the context of cases involving hemophiliacs, those two issues are raised as well, but the predominant focus tends to be the use of a heat treatment process to inactivate the virus, which was developed in late 1984. There are arguments that it perhaps ought to have been, well, it was developed and adopted by North American manufacturers in late 1984. There are arguments that the North Americans should have been sooner, and following the path of the Europeans who were using these processes in the early 1980s. As well, there are arguments that the process, having been developed, wasn't implemented and the product distributed quickly enough to avoid unnecessary infection. To look at the Pittman case and where it fell on these issues, Pittman did argue, the plaintiffs did argue, that the blood should not have been infected, and the date of the transfusion was December 1984, so the case was pitched at the level of donor screening, did not raise the ELISA testing issues. The case was unsuccessful on that basis. The conclusion of Madam Justice Lang is that the practices of the Red Cross were not negligent, and in particular, looking at the specific donor who had been identified, even had the practices been different, the donor would not have self-excluded or would not have been excluded from the blood supply because he didn't himself identify his risk factors. The second branch of the argument, the duty to avoid or the duty to warn so that the administration of products could be avoided, was not raised in Pittman. The third issue clearly was the duty to warn so that the risk of secondary transmission could be avoided, and it was on this basis that the case was successful. It was successful as against the Red Cross, against the hospital, and against Dr. Bohnen. It may be that that case was extremely fact-specific in that case a donor had been identified, or the donor who had given blood to Mr. Pittman, a subsequent unit of that donor's blood had been identified as HIV positive, raising the concern that previous donations had been positive, and that information was passed down the chain but took quite some time to get from the Red Cross to the hospital, 2 years to get from the hospital to the doctor, Mr. Pittman's treating physician, and it never got from Mr. Pittman's treating physician to his patient based on grounds of therapeutic privilege. So there was shared responsibility for that negligence there. Looking to developments since Pittman, what has happened as a general matter is that more parties have been added to all of the claims. In those cases in which the plaintiffs have not added all of the parties in the chain, and they would include the physicians, the hospital, the Canadian Red Cross, the manufacturer, the province, which was part of a committee called the Canadian Blood Committee, which directed blood policy and funded the introduction of blood safety measures, and also the federal government, which was responsible for regulatory aspects of the blood program and specifically was involved in the introduction of ELISA testing. To the extent that plaintiffs have not named those parties, the defendants have now brought a series of third-party claims to ensure that all of the proper parties are now before the courts in the litigation. The Red Cross predominantly brought in the provincial and federal governments and some physicians. Hospitals in some cases have brought in treating physicians, and in some cases the directors of their own blood banks, which was perceived to be a bit unusual in that the established or understood state of the law is that someone acting in the context of a blood bank director would be fulfilling duties, they'd be acting not in the role of a treating physician and therefore in some independent capacity, but as an employee of the hospital. Despite the fact that there have been, that the class action was not successful, there have been creative attempts on the part of the court to facilitate this litigation given its expense. And Madam Justice Feldman in particular has worked closely with the parties to establish a combination of test cases that will get specific issues of widespread importance before the courts in a timely and cost-effective manner. It's an interesting process. It arose initially out of a motion to have a single judge appointed under Rule 3715 to hear designated motions in an action. Once a judge was appointed to hear those motions in respect of one claim, it was then expanded and other actions were brought into this housekeeping kind of setup. And it was out of this forum that a proposal was initiated by Plaintiffs' Counsel to generate test cases. As a result of the proposal, 3 groups of test cases have been established or are proposed to go forward. The first group will go forward in the fall of 1996. These are transfusion cases that will raise issues relating to transfusion during the time frame October 1st, 1983 through to January 7, 1985. The second group of test cases is also a group of transfusion cases which will explore issues around transfusion from March 1st, 1985 through to August 7th, 1985, with ELISA testing and the alleged delay in the introduction of ELISA testing being the primary focus. And the third group of test cases are those which will bring into issue the hemophilia-related matters, and those are proposed for September of 1997. So there is a schedule to take us far into the future, but hopefully that will minimize the downside of not having a class proceeding to determine these issues in that way. Moving next to the question of the right of HIV-positive healthcare professionals to continue to practice, I think it's important as a factual matter to start with the point that as of May 1996, to the best of my knowledge, and I've tried to get the most current information available, the only reported case of HIV transmission from a healthcare worker to a patient remains the case of the Florida dentist investigated by the Centers for Disease Control in Atlanta in 1991. I think it's worthwhile to canvass the conclusions that were reached in that particular case. It was concluded that 6 patients contracted HIV from a dentist. The conclusion was drawn on the basis of the absence amongst the patients to other known risk factors for HIV and to a high degree of similarity in the viral strain of each patient to the other and also to the dentist. The CDC concluded that it was likely that the dentist in question was in the more advanced stages of disease progression at the time that transmission occurred, and that there were, as a result, higher levels of the virus in his bloodstream. All of the patients had undergone invasive procedures at the hands of the dentist, and the conclusion of the CDC was that it was more likely that there was a blood-to-blood transfer during invasive procedures, although the other possibility that was raised was through the use of contaminated instruments or other dental equipment. In either case, the most important factual point to arise from this situation is that the investigation revealed that it was likely inadequate adherence to recommended infection control measures, the rigorous adoption of barrier methods and sterilization procedures, which were responsible for HIV transmission in this circumstance. The adoption of universal precautions is generally recommended as a means of prevention of all bloodborne disease in the healthcare setting, and this appears to have been the problem. That is, had those procedures been in place and been rigorously adhered to, the transmission in question would not have taken place. The approach of licensing bodies for healthcare practitioners at present in Ontario appears to be generally consistent with guidelines established by the Laboratory Centre for Disease Control of Canada in Canada, and that's our counterpart to the Centre for Disease Control in the US. It's part of the health protection branch of the federal government. They established in May of 1996 infection control guidelines that address or set out the principles that are important in the context of healthcare worker responsibilities to their patient. And these principles are as follows. Number 1, first and foremost, adherence to recommended infection control procedures, in particular universal precautions. The second principle is that it is not appropriate to implement a policy of mandatory testing of healthcare workers. The third is that healthcare workers have an obligation, first of all, to know their status in relation to not just HIV, but any potentially blood-borne infection, if they have risk factors for acquiring that infection or if they have encountered a significant exposure. The second is that they have an obligation to seek care, including in particular counseling about the potential for transmission. The third is that healthcare practitioners have a responsibility to voluntarily modify their practices to minimize the risk of transmission to those under their care. The next principle is that that the ability to continue to work should be based on mental and physical competence, including adherence to specific practices, not to disease status. And that's probably the most important to be taken from this, most important point to be taken from it. It's not that someone has HIV that means they can't practice. That has to be assessed with respect to competence and competence only. There is no obligation on the part of the healthcare worker to tell their employer of their HIV status. And one caveat to this would appear to be in situations in which there has actually been an exposure. The LCDC has recommended that there is a responsibility to advise patients of significant exposures to HIV infection through in the healthcare setting on a non-nominal basis. That is, the patient must be told, but the patient need not be told the name of the healthcare worker and ought not to be told without the consent of the healthcare worker what that person's name is. Of course, as a practical matter, it's difficult because it may be that disclosing that there has been an exposure discloses the single event and through it the single healthcare practitioner. But those are the principles. And finally, there is no obligation on the part of a healthcare practitioner to tell a patient of his or her HIV status. Licensing bodies in the province have established more or less comprehensive policies relating to this issue. To my knowledge in Ontario, and I must say at the outset that I haven't canvassed every licensing body, but to my knowledge, the only body which requires self-identification or recommends self-identification to the licensing body is the Royal College of Dental Surgeons of Ontario, and certainly this was their policy as of October 1992. The nature of the recommendation put in place by the RCDS is that a healthcare practitioner should self-report. The purpose is to allow that person access to an expert review panel that would provide advice relating to modifications to practice, but clearly there would appear to be, there is an expectation that that body will provide assistance, and I think it's fair to expect from the perspective of the healthcare practitioner that the assistance may take a supervisory kind of role to the extent that a practitioner is not voluntarily adhering to practices recommended by the expert body. A clear question that arises, just to pick up on the last point arising out of the LCDC policies, the question whether a patient, whether a healthcare worker has an obligation to tell a patient of their HIV status, clearly raises the doctrine of informed consent as that is currently understood. And specifically, if we look to the definition of material risk as set out in the relevant case law, there are certainly grounds for advancing that proposition. If we look at Ribel and Hughes, the language of the court is that even if a certain risk is a mere possibility which ordinarily need not be disclosed, yet if its occurrence carries serious consequences, as for example paralysis or death, it should be regarded as a serious risk requiring disclosure. And in another subsequent case, White and Turner, material risks are significant risks that pose a real threat to the patient's life, health, or comfort. In considering whether a risk is material or immaterial, one must balance the severity of the potential result and the likelihood of its occurring. Even if there is only a small chance of serious injury or death, the risk may be considered material. So clearly there is the ability in the case law or using the case law to advance the argument that there might be a responsibility on the part of a healthcare practitioner to disclose their HIV status. To be weighed against it, however, and in my view this is a very important argument, is that the argument may be advanced that such disclosure is contrary to public policy, in particular as set out under the provisions of the Ontario Human Rights Code. The argument is that you're requiring a healthcare practitioner to disclose information that is confidential to them in a discriminatory manner. And if one looks to the reasonable accommodation analysis and the guidelines established by the Ontario Human Rights Commission to accommodate those, there has to be an objective assessment of the likelihood of the risk, number one. And given the fact that the only known incidents to date, and certainly these are only reported and the only ones known, but certainly the only evidence we have is that it is only the Florida dentist case in which there has been documented transmission from a healthcare worker to a patient. Similarly, the reasonable accommodation analysis requires some comparison of the risk associated with HIV transmission in this context with tolerance within society as a whole to other kinds of risks. And there have been studies done that suggest that the risk of HIV infection and death resulting from that in the healthcare setting are not, when you perform a risk assessment, out of kilter with risks that people voluntarily run in other contexts. Having said that, the key to the question is the voluntarily run part. So I just point it out as an issue. Certainly in the United States, there is a case that brought this issue to the fore and decided it in favor of the patient and in favor of full disclosure on the part of the healthcare worker. That is the case of the estate of Behringer versus the Medical Center at Princeton. It's a decision of the Superior Court of New Jersey, decided April 25, 1991. It was a case in which a healthcare worker, a physician, otolaryngologist and plastic surgeon, himself became admitted to the hospital in which he had surgical privileges as a result of an HIV-related condition, and his HIV status was diagnosed within the hospital, and information became widely known within the hospital of his status. Within a few weeks of his diagnosis, his surgical privileges were suspended, and the plaintiff, his surgical privileges were suspended. He was subsequently permitted by the hospital to go back to practice, but on the caveat that he provide his patients with that any patient undergoing surgery be required to complete an informed consent form that specifically disclosed the HIV status, his HIV status. I think the language of the court is interesting in the concluding paragraphs of their judgment. They read as follows. The obligation of a surgeon informing invasive procedures such as the plaintiff to reveal his AIDS condition is one which requires a weighing of the plaintiff's rights against the patient's rights. New Jersey's strong policy supporting patient rights weighed against plaintiff's individual right to perform an invasive procedure as part of his practice of his profession requires a conclusion that the patient's right must prevail. At a minimum, the physician must withdraw from performing any invasive procedure which would pose a risk to the patient. Where the ultimate harm is death, even the presence of low risk of transmission justifies the adoption of a policy which precludes invasive procedures when there is any risk of transmission. In the present case, the debate raged as to whether there was any risk of transmission, and the informed consent procedure was left in place. If there is to be an ultimate arbiter of whether the patient is to be treated invasively by an AIDS-positive surgeon, the arbiter will be the fully informed patient. The ultimate risk to the patient is so absolute, so devastating, that it is untenable to argue against informed consent combined with a restriction on procedures which present any risk to the patient. My understanding is that the American Hospital Association does not advocate a policy of disclosure on the part of healthcare practitioners of their HIV status to patients. Having said that, I understand that the practical effect of this decision has been to create a lot of pressure within healthcare institutions to adopt similar policies to those that were adopted here and upheld here by the court. At a policy level, the concern that has to be raised and considered in coming down on this issue and making a decision is whether in requiring disclosure to a patient, one will ultimately create a greater level of risk. And the argument is certainly made that if one requires healthcare practitioners who are HIV infected to disclose their status, there will be a disincentive to identify one's status, to seek relevant care, and at the end of the day increase the level of risk to the patient. The last area that I'd like to touch on is the Health Protection and Promotion Act. This is a piece of legislation that establishes the framework for the delivery of public health services in the province of Ontario. It operates to divide the province into 42 health units, and within each unit is administratively independent and has a medical officer of health responsible for exercising powers and responsibilities in relation to communicable disease and also in relation to environmental health hazards. But I'm going to focus specifically on the communicable disease provisions. There are a number let me just say at the outset, there are a number of difficult and unresolved issues with respect to the operation of the Health Protection and Promotion Act in the context of HIV disease. I simply raise the provisions here because I think it's important to be aware of the existence of this legislation and its basic elements. I'm going to touch on 4 areas. The first is to set out a basic framework of the Act. The second is to talk about the reporting obligations established by the Act. The third is to touch on the confidentiality provisions of the Act, and the fourth is to very briefly talk about the capacity to issue orders under the Act. Dealing with the basic framework, the stated purpose of the Act, which is important, is and becomes very important in the context of the use of powers under the HPPA in the context of HIV disease, is that the purpose of the Act is to prevent the spread and transmission of communicable disease in the province. And it's my own view that any exercise of the powers under the HPPA must meet with that objective. If they do not, it may be that a jurisdictional issue could be raised in relation to the exercise of powers in this context. The range of what the Act does is to categorize communicable diseases as communicable, or categorize infectious diseases generally as communicable, reportable, or virulent, and not every infectious disease is designated as one of these things under the Act, but there are lists of them that are, and HIV is designated as a communicable and a reportable disease. The Act operates to create reporting obligation and reporting obligations in respect of reportable diseases, and the reporting obligations extend to a variety of healthcare practitioners. They're set out at sections 25 through 29 of the Act. They relate to physicians, persons registered under the Health Disciplines Act and presumably now under the RHPA, administrators of hospitals, superintendents of institutions, and those are defined under the Act, principals of schools, and operators of laboratories. I'll just turn to one of the reporting provisions to give you some idea of the information that triggers a report and where some issues of interpretation arise. Section 25 requires a physician or a person registered under the Health Disciplines Act, now replaced by the RHPA, who, while providing professional services to a person who is not a patient in or an outpatient of a hospital, so a patient outside the hospital context, forms the opinion that the person has or may have a reportable disease, shall, as soon as possible after forming the opinion, report thereon to the medical officer of health. So the question is, when does one form the opinion that a person has or may have a reportable disease? And certainly one interpretation that has been taken is that a receipt of an HIV, an antibody positive result for HIV is what invokes the reporting provisions under the Act, or alternatively, it's certainly a possible interpretation that the development of clinical symptoms may invoke the reporting provision, but I do not understand that to be an interpretation widely held in the health unit. From the perspective of a healthcare practitioner, I think the best advice is that they ought to consult with the medical officer of health in their own health unit. Of interest, I think, is that in the case of Dr. Bohnen, before his prosecution for professional misconduct before the College of Physicians and Surgeons, he was convicted of professional misconduct for, in part, failing to report to the medical officer of health information he had received as a result of the Red Cross Look-Back Traceback program that his patient, Mr. Pittman, may have been exposed to an agent of the virus. In the context of the civil trial, this was not held to be important evidence from the perspective of Madam Justice Lang, who considered the range of compliance with the reporting obligations under the Act to be so varied that she wasn't prepared to draw the conclusion that to fail to report was indicative of negligence on the part of Dr. Bohnen. Turning very quickly, I see I'm almost out of time, to the confidentiality provisions under the Act. At the same time as the Health Protection and Promotion Act creates a framework for the reporting of information to facilitate public health interventions, it also creates a clear legal requirement to maintain the confidentiality of information relating to reports in respect of persons with communicable or reportable diseases, and that's found at Section 39 of the Act. No person shall disclose to any other person the name or any other information that will or is likely to identify a person in respect of whom an application, order, certificate, or report is made in respect of a communicable disease, a reportable disease, a virulent disease, or a reportable event following the administration of an immunizing agent. There are some exceptions to the Act, to that overall provision, but it's clear that there is an intention to provide an umbrella of protection over this information. Mr. Steinecke is going to deal with the question of confidentiality, and I add only this in the context of HIV, is that this provision provides a clear legal statement of entitlement to confidentiality within the context of the public health system and those healthcare actors feeding into that system. And certainly in the context of any breach of confidentiality within that system, one might plead reliance on the provisions of this Act and also consider whether it's appropriate to initiate a prosecution for breach of provisions of the Act. There are enforcement provisions which provide that a breach of the Act is a provincial offense, and the enforcement provisions provide for punishment in the nature of, for individuals, fines of up to $5,000 per day, and for corporations, $25,000 per day. So there are enforcement provisions that are there. Turning lastly to the question of the capacity, actually there was one other point I wanted to raise in relation to confidentiality and HIV, and that is that there's no question that the courts have taken a very strong view of the importance of maintaining the confidentiality of this information or information relating to HIV status. There are a couple of examples of that. One is a case that I've got here from the Saskatchewan Court of Queen's Bench, in which a correctional institutions worker who arrived in the staff lounge to find a typewritten list of persons in which persons were listed from whom body fluid precautions should be taken, and she was on the list because she had been previously exposed or previously contracted hepatitis B. She brought her action on the basis that to identify her as someone in respect of whom body fluid precautions should be maintained was to suggest that she may have AIDS, and that was specifically her complaint, and the court upheld her breach of confidence and looked to that issue. So there's no question that the court takes the question of information relating to HIV status very seriously indeed. The second is that, or the second evidence, the other source of evidence that we have from this is a bit of a digression, but courts have been receptive to plaintiffs in the context of HIV-related litigation, moving to secure the protection of the court to bring their proceedings using pseudonyms or to seal certain portions of the court record in order to protect their confidentiality. And given the strong bent of our courts in favor of the openness of all procedures, I would suggest that that's evidence of their sensitivity of the importance of this information and the consequences that can flow from its disclosure. Turning lastly to the question of the capacity under the Health Protection and Promotion Act for orders to be issued, the relevant provision is Section 22 of the Act, which allows a medical officer of health to issue an order and I think it's most helpful to track the actual language of the statute, to require a person to take or to refrain from taking any action that is specified in the order in respect of a communicable disease. And again, HIV is listed as both a communicable and a reportable disease. In order for an order to be issued, there must be reasonable and probable grounds that a communicable disease exists or may exist, or that there is an immediate risk of an outbreak of communicable disease in the health unit, that it presents a risk to the health of persons in the health unit, and that the requirements specified in the order are necessary to decrease or eliminate the risk to health presented by communicable disease. And there are a list of specified provisions that could be found in such an order, and with the preliminary language that such an order is not limited to those elements that have been listed. There are important limiting principles nonetheless to be borne in mind in the context of Section 22 orders. One is the requirements for necessity that are built into the language that I described. The second is the overall stated purpose of the Act as set out in Section 2, which must be to reduce the risk of transmission of disease in the province, and to the extent that the use of these orders may be said to increase that risk, then that may be grounds to reconsider whether they are appropriate. And certainly I raise that point because that is one concern that has been raised within the community of persons infected and affected by HIV. There is also the prospect of a constitutional limitation on Section 22 orders, in that the province is only able to take actions in relation to the purpose of for the purpose of protecting the public health. This legislation cannot be used to punish behavior seen to be criminal in nature. So there can't be a use of this legislation to achieve a criminal prosecution in effect more easily. And it may be that there are charter issues or charter challenges that can be raised to sorry? I'm just winding up this section. The last point that is worth raising in relation to the use of Section 22 orders is that to the extent that they are used, there is a right of appeal from such an order in the first instance to the Health Protection Appeal Board, and then there is a broad right of appeal to the Divisional Court, and from that point on. Thank you. Those are my comments.
Thank you very much, Laurie. Richard was acting as my proxy and for the hook, so if from time to time I have to wave these signs around, you can appreciate it. But because Laurie has to go and won't be able to participate in the question and answer session, we thought she'd spend a bit more time at the outset. If there are any questions you have for Laurie, perhaps you can write them down and direct them to me, and I will pass them along to Laurie, and we'll get answers out to you.
Thank you.
Our next speaker is Richard Steinecke, who is a partner with the firm of Porter, Parsons and Harris. He is a specialist in civil litigation, as certified by the Law Society, practices exclusively in the area of professional regulation. He acts as general counsel and prosecutor to regulators. He acts as independent legal counsel to tribunals, and also as defense counsel. He was retained to assist in respect of Bill 100 by the Coalition of Regulatory Colleges. He has published a book called A Complete Guide to the Regulated Health Profession Act, which is competing with Linda Bohnen's book, so perhaps after they can comment on that. I hope not.
Maybe not.
And Richard also is the author or editor of something called Gray Areas, which is a newsletter dealing with professional discipline regulation. Richard will be talking this morning on confidentiality and access to medical records.
Thank you. I have some overheads so you can follow along with what I'm discussing with you. I hope you can see them. First of all, I'd like to specifically mention Julie Makura from our office, who did the lion's share of the paper in your materials, and I appreciated the work she did on that. You'll be relieved to know that I'm not going to follow or read out my paper to you. I want to try and place a framework on the understanding of confidentiality and access to health information, particularly the right of third parties to have access to a patient's records. And there's two major themes that I think flow from this topic. The first is you're dealing here with a tale of competing duties. The common notion is that the duty of confidentiality is paramount, and that's still said, and that goes all the way back to the Hippocratic Oath and probably beyond that. But the reality is that there are multiple obligations to disclose confidential health information, and it's very hard to keep a track of those obligations. And that leads to my second point. The complexity of the various duties and obligations are beyond the ability of a busy practitioner to keep pace. And I want to start off with a scenario of Dr. Hansen's case. This is a very fascinating case down east, as they say. Dr. Hansen somehow learned, I don't know how, but learned that Mr. Ross had been convicted of sexual assault, and the complainant was his former patient. He was a psychiatrist. And he had the belief that her psychiatric condition was such that she might honestly believe that she'd been assaulted by Mr. Ross, but was wrong about it. And so what was he to do, having found out this information? What would any practitioner do? Well, he went to his regulatory body, and while the information is far from complete, his side of the story is that they were not much help, and so he took a risk, and through his own lawyer, got his own legal advice, through his own lawyer, he told the Crown Attorney that he had information that there may be a miscarriage of justice in this case, and that he was the treating psychiatrist for the complainant. And he said nothing more. And so the Crown and the defense tried to get the consent of the complainant for the release of the information, and they said no. And she said no. And so it was taken to court, and the court ordered that he produce the information, be questioned on it. Now, the file, there's another proceeding involving his regulatory body, and that file is sealed through the vigorous efforts of Mr. Fraleigh's counterparts down east. So we don't know what happened there, but the implication is that he has been disciplined for what he did. And hopefully we will someday find out what happened in that case to see how that tribunal and the courts adjust to it. Now, I think a fundamental way of understanding these competing interests and understanding this law is to try and understand the basis of the duty of confidentiality. Now, often lawyers, they like to talk about the legal basis of something, and it gets quite boring, but in fact, this has significance as to what the content and extent of the duty is. For instance, what do you have to report? What weight do you give to these competing interests for disclosure? And the consequences of a breach of the duty of confidentiality. So let's use the example of someone who is being assessed by a third-party practitioner. Let's say that an insurance company hires a practitioner to examine a person for the benefit of a report to the insurance company. Your typical third-party assessment. Okay? Now, is that covered by the duty of confidentiality? And does the person who's been assessed have the right to obtain access to those records? or do they belong to the insurance company who's ordered and paid for this assessment? Well, the first way of looking at the duty of confidentiality and access is to say, well, this is professional misconduct. That every or almost every college has a definition of professional misconduct that explicitly says it's professional misconduct to disclose confidential information unless required to do so by law. And an interesting question arises, need this be explicitly mentioned in the definition of professional misconduct? I was surprised recently to hear that the College of Pharmacists does not have an explicit duty that says you must keep it confidential. But I think it is generally accepted that there is still a duty of confidentiality among pharmacists to not disclose confidential patient information. And so probably it does not have to be explicitly stated. It could probably fit under what you call the catch-all clause. But okay, let's say you have this duty of confidentiality in your professional misconduct regulation. What is the extent of that duty? It depends, of course, on the wording, but the typical wording refers to a patient. So the question is this third-party assessment you're doing, is the person you are assessing your patient or not? And there's a lot of debate. And in fact, I think on this platform you probably get disagreement on that point. My view is that there are some elements of the patient-practitioner relationship there that would impose a duty of confidentiality. Another interesting question arose in a case that was sort of notorious 20 years ago involving a Dr. Schulman who published a newspaper article about the treatment of a particular patient by another physician. And he was disciplined on the basis that he had breached the duty of confidentiality even though this person was not his patient but the patient of somebody else. Presumably he got this information through the plain brown paper envelope. And the discipline committee and the divisional court held that yes, he did have a duty of confidentiality to somebody else's patient, even though he had no relationship to that patient. So under this analysis, the weight to be given to the competing interest really comes down to the wording of the provision, which says that you can only disclose if permitted to do so by law. Not by policy, not by professional values, but by law. There must be a legal obligation or legal authority to make the disclosure. And the consequences of that breach then would be that you would be disciplined. Okay, so far not too bad. Now, what about in the civil context? Is there any kind of civil obligation to the person for confidentiality purposes? And until about 5 years ago, I think most of us would have said, well, there's a contract between the patient and the practitioner. And it's an implied term of that contract that you would keep the information confidential. And so if you took that approach, then you would only have an obligation to someone that was a party to the contract to your own patient. So in Dr. Schulman's case, you couldn't sue necessarily, and certainly in a third-party assessment, you might not be able to sue for access to the charts yourself as the person being assessed, or if the information was disclosed elsewhere. The contract was between the assessor and the insurance company. And so what weight would be given to the competing interest? The only weight that would be given to the competing interest would be what was implied by the terms of the contract. And the consequences of that breach would be civil damages. Now, people, I don't think, have ever found that to be totally satisfactory. And so people have tried to develop another way of approaching the issue of confidentiality. And from time to time, people have tried to say, well, there's a legal privilege similar to the privilege that exists between a lawyer and a lawyer's client, between a practitioner and a practitioner's client. So this has been argued from time to time, but it's never actually worked. It's never caught on. The courts have never really accepted this except in very obscure circumstances. So the extent of the duty here would be only to your client. It probably would not be to a third-party assessment. It would be similar to a lawyer's obligation to a witness. You don't have much of an obligation to a witness, but you do have a heavy obligation to your patient or your client. So the weight to be given to the competing interest under this analysis would probably be much less, because there's very little that overrides the duty of a legal privilege. And so the consequences of that breach, if it existed, would be civil damages, perhaps even with punitive and exemplary damages. As I said, this analysis never really caught on, and a few years ago we had a new analysis in McInerney and MacDonald, and that case is in the materials, which says that there's a fiduciary obligation arising from the special relationship of trust and confidence between a practitioner and a client or a patient. And so the extent of the duty applies to anyone who places trust and confidence in the practitioner. And the weight to be given to the competing interest would need to be quite strong, because it would take quite a bit to override a fiduciary duty of special trust and confidence. And the consequences of this breach, of breaching that duty, would be quite significant. It would be civil damages and, in all likelihood, punitive and exemplary damages. And so this is, I think, where the courts have been going recently. So now, come back to the example of a third-party assessment. Under this last analysis, under a third-party assessment, the person probably does place some special trust and confidence in the person doing the assessment, and would have some right to have access to those records and to have that information kept confidential. And in fact, there's a case called Parslow and Masters that held exactly that, and that's in the materials that you have before you. And it's a Saskatchewan case, and it's a lower court case, so we don't know how far it will go, but it was quite a good analysis of this issue. So I think if you look at that kind of analysis, you'll see that that it really affects the extent and nature of the obligation of confidentiality. Well, let's start looking now at some of the competing interests. And I want to divide those competing interests into two categories for the purposes of today's presentation. The first is the accused's right to make full answer in defense, and that was in the Regina and Ross case. And the more famous case now is Regina versus O'Connor, in which there is a claim that a person who's been charged with a criminal offense can go to the court to get access to the information and the records, to have production of the chart of the complainant who is making this complaint against him or her. And the courts have held that sometimes, in fact, you can have that access. A second category of competing interests are sort of the generic duty to warn, duty to notify by statute or by common law. And one example, of course, is the duty of some practitioners to report unfit drivers. Now, what are the distinctions between these two kinds of categories? Well, first of all, who initiates the disclosure? Who initiates the disclosure in these two cases? Well, in the first case, it's the person who wants the information, the accused person, who initiates the disclosure. In the second case, it must be the practitioner who himself or herself initiates the disclosure, the reporting of the confidential information. Secondly, who decides whether the competing interest applies to these facts? In the first scenario, it will be a court who will make a determination as to a balancing of the interests. In the second case, it's the practitioner who, at least in the first instance, must say, I have to balance these interests and decide whether I must report or notify in these circumstances. And then the third distinction is the enforcement of the duty. In the O'Connor case, it's a prospective ruling. So it is, you are told you must do this, and you must. And secondly, in the second scenario, you are punished after the fact if you have incorrectly balanced the competing interests. To look at it a little more detail then in the first competing interest, the accused's right to make full answer in defense, there are two very compelling, but very opposite interests here. The first interest is the right of the accused person to defend himself or herself, to make a full answer in defense. And that's a very strong interest, especially among lawyers. And secondly, there is the privacy rights of the patient and the complainant, who sometimes has disclosed very intimate details about themselves in the expectation that no one would have access to that information. And so how do you balance these competing interests? And the courts have set up a two-stage process, and it's quite clear now what the process is to be followed. First of all, there's a screening of the likely relevance of the records, and if the court believes that the records are likely relevant, then they will actually look at the records and balance the competing interests of the person who's defending himself or herself against the patient complainant who has this confidential information. And in my paper, in our paper at page 10, you see this. The process is now clear. The problem is, how do you apply that process, that test, to a particular set of facts? And there's a couple of significant problems here. The first one is, whose values are you relying on? And there really is no consensus in our society, in my view, on how to balance these interests. Some of us were involved in the development of the Sexual Abuse Amendments, Bill 100 to the Regulated Health Professions Act. And we were involved sometimes with regulatory bodies. And so one day we would go out with our regulatory body clients, and we'd meet with representatives of the defense bar. And they would tell us about how you must be able to preserve at all costs the right of the member to defend himself or herself, and you can't encroach on that at all. And then the next day, we would go out and meet with advocacy groups for survivors of sexual abuse. And you would hear exactly the opposite kind of value. And you would just be afraid to put those two groups in the same room. You'd think that no one would get out, someone would not get out alive. And so these values are very different. They're very far apart. And I think it's going to be very difficult to sort out these values. And the other thing that's not clear is the role of the practitioner in all of this. When this process is going on, what's the practitioner supposed to do? Is the practitioner a witness, or an intervener, or a party? It looks like they're likely have sort of intervener status, but that's not entirely clear. And secondly, what's the practitioner to do there? Is the practitioner to be an assistant to the court, or is the practitioner to advocate a particular position, perhaps on behalf of the patient, or perhaps on behalf of the public interest as a whole? And so those sorts of issues have to be sorted out over time. Now, the second category of competing interests are the statutory duties. And generally, these reflect important values. Unfit drivers is an important value. Child abuse, preventing and dealing with child abuse is an important value. Sexual abuse of patients, contagious diseases. These are all important values that must be dealt with. The problem is that the existing system is a patchwork quilt that has no consistency to it. It's inconsistent as to who must make the report. For some obligations, it's physicians only. For some obligations, it's physicians and a few other healthcare practitioners. For some obligations, it's all healthcare practitioners. And for other obligations, it's everyone. The statutory provisions also are inconsistent as to what must be reported. For example, should the name of the subject of the abuse or the subject of the danger be reported? Well, in the child abuse provisions, the answer is yes. In the sexual abuse by health practitioner provision, the answer is not unless you have the written consent of the patient. So what happens if you are dealing with a situation where you have found out that a practitioner, a healthcare practitioner, has sexually abused a child? And you've learned this in the course of your practice. What do? Well, you go to the Children's Aid Society and you tell them the name of the patient, and you go to the college of the person who allegedly did the abuse, and you only tell them the name of the patient if you have the consent of the child or the child's guardian. So it gets quite confusing. And then there's also the inconsistency of the enforcement of these provisions. And you heard Laurie Stoltz speak a little earlier about the inconsistency in the result of the Pittman case, the Dr. Bain case, before his own regulatory body and in the civil courts. The other problem with these statutory duties is that there's no single location for these obligations. These duties are contained in multiple statutes, and practitioners are expected to know them all. And I defy anybody to name them all. I don't think I could name them all. I don't think anyone in this room could name all the statutory obligations that apply to practitioners. The other problem with these obligations is that they're statements of rules rather than principles that turn on the particular wording of the provision. And to look at a couple of examples, for the reporting of sexual abuse or of child abuse. Let's look at that in the Child and Family Services Act. There are two duties there. There's a universal duty that applies to everybody in society, where you have reasonable grounds that a child under 16 is or may be in need of protection. And that definition of need and protection is 2 pages long and is quite broad and includes physical abuse, sexual abuse, neglect of basic needs, including health care, and if the child has committed a crime. On the other hand, there's also a separate professional duty that applies to only listed professionals, including, I think, every healthcare practitioner. And this applies only to information obtained in the course of professional or official duties, which is different from the first one. Secondly, it applies if you have reasonable grounds to suspect, as opposed to reasonable grounds to believe. And again, the child and is or may be suffering abuse, which is defined differently from the need of protection definition. Now, what happens if the child was 16 at the time of the abuse, but now is 30 and has told you about it? Need you report that? I've asked a number of people to answer that question. I haven't got a straight answer. The best I can tell is that it depends on whether or not the abuser is at risk of abusing someone else. I'll move now to the common law duty to warn. And this starts off with the Tarasov case, which is sort of a great academic case. I remember studying it in law school, and it's sort of great to talk about at cocktail parties. But now it's starting to become real. It's starting to become something that we need to know about. It involved a patient in psychotherapy who threatened to harm another person. The therapist kept that information confidential. The patient went out and killed the person they had threatened to harm. The estate of the person who was killed sued the therapist for failing to warn. And the California court held that this was a cause of action that existed in California. The issues is this good law in Ontario? It's been applied in Alberta and England, but to my knowledge it hasn't been squarely applied in Ontario. I know of practitioners who in fact do apply this principle. There was one college that received a complaint about a patient came in with HIV and said that they were going to have unprotected sex with their friend who was in the waiting room. So the practitioner sent the patient out, called the friend in, and realized that that person was handicapped, was mentally handicapped, and warned that person of the risk of having unprotected sex with the patient because that patient was HIV positive. And so that complaint was made to the college, and the defense was, I had to warn this person. And in fact, I think it was accepted by the complaints committee. So that's one thing. Secondly, can you expand this duty? This duty applies to a risk of harm. Physical harm, can you expand that duty to other categories, for example, in the Ross case, to a miscarriage of justice? And I think that we could be seeing the Tarasov case becoming much more robust and expanding to other areas. Does it matter whether you are using the principle to defend yourself from making disclosure in the past, or whether you are using it to assert a right to make disclosure, like in the Ross case? It shouldn't matter, but practically it might. And what do practitioners do in the meantime while this is all sorted out? Now, there is statutory reform coming, we're told. Bill 41 is a private member's bill by Eleanor Kaplan, which received unanimous second reading. It's not clear if this bill is actually going to go anywhere, despite the fact that it's gone so far already. But that bill provides for patient access to their own records except as prohibited by law. And there are very few, if any, prohibitions to disclosure to a patient in law. Generally, in McInerney and MacDonald, you must disclose unless there's harm to the patient or harm to someone else. So you have to do that kind of balancing. That kind of balancing may not exist if that bill is enacted. There's also a comprehensive statute on health, information, and privacy that's coming. This was first proposed in Mr. Justice Creever's former commission in the 1970s, and it's been proposed many times but has never actually made it. And apparently this June, a discussion paper is going to be disclosed, unveiled at a conference. I think there would be some benefits if this was done properly. You might get some consistency, you might get some clarity, you might even, although I'm not sure, have all of these disclosure obligations in a single place, and the statute might bring a principled approach to this rather than a set of rules that depend so much on the wording chosen. My concerns are that we might just end up with one more source of rules, which would make the present scheme even more complex. And we might end up with some of the drafting difficulties we already have. For instance, the two-page definition of child in the need of protection in the sexual abuse case. And finally, I don't think that this legislation can solve the basic problem of competing values that change over time. And it's an insoluble problem. And I take the case of Halls versus Mitchell, 1928 decision of the Supreme Court of Canada. The doctor worked for a railroad that was contesting a workers' compensation claim made by Mr. Halls. The doctor had treated Mr. Halls after World War I and believed that Mr. Halls had had venereal disease at that time. In the course of his treatment, he'd learned of treating Mr. Halls, he'd learned that, and he used that information for the purposes of the workers' compensation case to help the railroad defend the case. Don't ask me how, but he did. And so Mr. Halls sued for defamation. Apparently he didn't, in fact, have venereal disease. And so there was a wonderful debate in Supreme Court of Canada on how far this duty of confidentiality should go. And it was nip and tuck, but in the end, the majority agreed that this was an improper disclosure of confidential information, that the value of privacy of this patient outweighed the right of the railway to contest the workers' compensation case. But it was not a majority decision. And 4 years earlier, the Ontario High Court, in a case just called C versus D, and this is 1924 56 OLR 209, dealt with a similar case with a slightly different fact situation. A teenage woman was thought to have venereal disease. She was a domestic in someone's household. The physician went and told the father of the teenage woman and the employer of the teenage woman in the household that she worked in that she had this disease and was sued. And the court held that the doctor's duty to disclose outweighed the patient's duty of confidentiality in that information. I'm positive that case would not be decided the same way today, but it shows you that with these values that change over time, how can you possibly enter into this kind how can you find an easy solution to this problem? Thank you very much.
Thank you, Richard. We'll now turn to consent to treatment issues. Linda Bohnen was called to the bar in 1976. She practices at Miller Thompson. She provides general legal advice as well as policy advice to hospitals, regulatory bodies, professional associations, public sector bodies. She is a frequent speaker on these issues, and her book is called Regulated Health Professions Act, A Practical Guide. It was published in 1994. She was in the past executive director of the task force on the implementation of midwifery in Ontario. She worked on health professions legislation review. She was also a senior Ministry of Health lawyer responsible for drafting the Regulated Health Professions Act and overseeing its progress through the legislature. Linda.
Thank you. Richard, there's no reason that they can't choose to be both practical and complete, don't you think? It wasn't very long ago that the Consent to Treatment Act was proclaimed in force. So you'd think that I would be here today talking about the legal issues that have arisen from implementation of that act. But it was not to be because, of course, the Consent to Treatment Act has been replaced by the Healthcare Consent Act 1996, which was proclaimed in force March 29th, with much less fanfare than the proclamation of the Consent to Treatment Act. So instead, I'm here today to talk about the significant differences between the two acts. Now, I will assume a certain amount of knowledge about the Consent to Treatment Act, although I suspect that many of you, like me, kind of put the CTA at the back of your minds as soon as you heard that there was going to be a new act, because it was so difficult to learn in the first place. Which is probably one reason, but not the only reason, that the CTA has been replaced. I think the primary reason is that the Progressive Conservative government had such philosophical differences from the NDP government that had enacted the CTA. And I guess the decision to dismantle the Advocacy Commission kind of exemplifies the philosophical differences, as well as some of the provisions that we'll come to. As you may be aware as well, the CTA was very severely criticized by health profession groups and institutional groups, and in particular physicians, who said that, basically, that it could not be implemented, or if it could be implemented, it would only be at the cost of quality and timely health care. Well, that might have been a self-fulfilling prophecy, but I don't think anybody would claim that the CTA was widely implemented in Ontario. When I visit health professionals myself, I'm always amused to see how in so many quarters there's still absolutely no recognition of any legal responsibility to obtain informed consent to treatment. You think that they'd know better with me, but they don't. Fortunately, though, this is one occasion when a successor statute is a whole lot better than the one that it replaced. It's much better organized. It's easier to understand. And that's really important because this legislation, unlike so much legislation, depends on thousands and thousands of healthcare providers understanding it and buying into it in order for it to be implemented. It's also much wider in its application and more flexible in its application. And in particular, it applies to admission to long-term care facilities and as well to decisions about personal care services, personal assistance services, as well as decisions about consent to treatment per se. The CTA only spoke to consent to treatment. So let me begin by talking firstly about the significant new provisions with a brief diversion on how the two acts are similar. To the extent that both acts dealt with consent to treatment of capable persons, both acts largely codify the common law. And in this respect, I'll call it the new act, I think, instead of the HCCA when I'm speaking. The new act is very similar to the old act in that respect. In both acts, a health practitioner who proposes a treatment cannot administer it and must take reasonable steps to ensure that it is not administered without consent. In both acts, the consent must be obtained from the patient if the patient is capable in relation to the treatment, or from the patient's substitute decision maker if the patient is incapable. The substitute decision maker may also consent to admission to hospital, psychiatric facility, or another facility for the purpose of the treatment, with some exception in relation to psychiatric facilities. Again, capable has the same meaning in both acts, and it means that the person or the patient is able to understand the information relevant to making a decision and able to appreciate the reasonably foreseeable consequences of a decision or a lack of decision. In both acts, there is no minimum age of capability to consent, and capability is presumed in both statutes. As well, capacity fluctuates from treatment to treatment and from time to time in the same patient. So this puts a considerable obligation on the health practitioner who's proposing the treatment to assess the patient's capacity on that particular day in relation to that particular treatment. The same definition of capacity applies to decisions about admission to long-term care facilities and the decisions about personal assistance services, although again, the nature and degree of the capacity varies with the decision to be made. What treatment is, though, is different in the two acts. The definition section starts the same, but diverges through the exceptions. There are two new, quite important exceptions. One that I've mentioned indirectly through personal assistance services, which itself is a defined term. And there is another exception for treatments that, in the circumstances, pose little or no risk of harm to patients. Okay? That exception, the one for little or no risk of harm treatments, responds to the criticism that the old act unnecessarily invoked the whole paraphernalia of the act, which included making findings of incapacity, notifying the patient of the findings, figuring out who the substitute decision maker was, et cetera, that was quite excessive in relation to treatments that really carry no risk of harm or little risk of harm. I think in accepting that argument, you see the philosophical turn in this act towards focusing on consent to treatment to ensure that individuals have the necessary information before they make decisions about treatments that might harm them physically, as opposed to an emphasis on consent to treatment in order to preserve autonomy and dignity of the individual. Okay, because you can see that I think that even if the treatment is completely free of risk, it might pose an assault to someone's dignity. There was always a conceptual problem, though, with the exceptions, and that's because in both acts, the common law still applied to acts and procedures not covered by the definition of treatment that appears in Section 8 of the new Act. But the common law does not, never did, still does not adequately give you a system for substitute decision-making on behalf of incapable adults. In general, no one has had proper legal authority to make decisions for incapable adult patients, and healthcare practitioners have coped by adopting the expedient practice of obtaining decisions from patients' next of kin. But prior to the enactment of this legislation, that's really done on dubious legal authority, and therefore places the practitioners at some legal risk. Now, under the CTA, the exceptions fell into that kind of common law void, and therefore it wasn't clear who would have the authority to consent to a treatment on the person's behalf, assuming that they did not have an attorney for personal care or a court-appointed guardian of the person. The new Act overcomes this through an opt-in provision, which enables the health practitioner to decide to treat something that's excluded from the definition as a treatment nevertheless. Not all of the exceptions can be treated in that way, but two that can be are the low risk or no risk treatments and an assessment or examination of a person to determine the general nature of his or her condition. If the health practitioner does decide to opt in, then the whole Act and all the regulations will apply so that the patient will have the same rights of appeal to the Consent and Capacity Board. Now, when would you opt in? I think that you'd be most likely to opt in if you're the health practitioner if you have an incapable patient who is refusing a low risk but necessary procedure. By virtue of opting in, you can obtain a consent from the patient's substitute decision maker. And if that consent is given, the consent will be valid and the practitioner will be protected from liability. Now, it's not foolproof, of course, if that's the right term, because the substitute decision maker, in deciding whether or not to give consent, must act in accordance with any wishes applicable to the situation that were expressed by the patient while the patient was capable and at least 16 years of age. But if you did have an incapable patient who was refusing to consent to perhaps a simple test or a preventative procedure, you do have a mechanism to opt in and obtain a substitute decision. Now, the new part of the Act that deals with personal assistance services is important. A personal assistance services is defined in essence as assistance with a routine activity of living, such things as assistance with or supervision of hygiene, washing, dressing, elimination, and such like. It also can include a group of personal assistance services or a plan. Now, Part 4 of the Act sets out pretty much a parallel, although slightly streamlined, system for obtaining decisions from substitute deciders to personal assistance services. But it's not mandatory, again, it's optional. If the patient or the resident, you'll see it only applies to persons who reside in certain types of facilities. If that person is assessed as an evaluator, as incapable of making a decision about personal assistance services, then that recipient or patient's substitute decision maker can make the decision. The principles are the same as applied to making decisions about treatment. For example, giving effect to the person's wishes expressed while capable and over the age of 16, acting in accordance with the person's best interests, and there are parallel rights of appeal to the Consent and Capacity Board. One of the real innovations of the Act was to change the name from Consent and Capacity Review Board to Consent and Capacity Board. Now, right now, this part will only apply to individuals in homes for the aged and nursing homes, but it is possible to make regulations to include individuals in other places as well. And I hope that the government will be so moved to make these regulations so that Part 4 of the Act expands to other locations. It seems to me that even an individual who is being cared for at home might benefit from having this opt-in system available. Okay. The CTA left a lot of issues unclear, which was one of the reasons why it was loathed by health practitioners, by and large. And one issue that was left unclear was whether a consent that had been given on behalf of a patient continued to be effective if the patient moved to another setting, or if the treatment had to change slightly. For example, if the specific drug changed from one antibiotic to another, would that mean that you'd have to go back to step one and obtain a new consent? Or if the patient was moved from one facility to another facility, was the consent still valid? The new Act clarifies this by providing that unless it's unreasonable to do so, the health practitioner is entitled to presume that the original consent included variations and adjustments in the treatment and to the continuation of the same treatment in another setting, provided there is no significant change in the expected benefits, material risks, and material side effects. Okay, consent to treatment plans. The old Act provided for treatment plans, that is, a group of varied health services comprising treatments that would be provided to the patient by varied health practitioners. But it didn't speak to the logistics of containing consent to a treatment plan. For example, could a physician alone, a mere physician, obtain consent to a treatment plan that included physiotherapy or speech therapy? The new act makes it clear that that can occur. However, remember that in order for the consent to be informed, it is necessary for the practitioner obtaining the consent to be able to provide all the relevant information required by law and to answer the individual's questions. The best result of this would be if consent to treatment was obtained from the patient or a substitute decider by a team meeting together. That may not happen, and in fact, you may find that the information is given in a rather piecemeal fashion, to the extent that it is given at all, and that the focus is still placed on the most high risk of the treatments, probably those to be administered or provided by the physician. Or perhaps this will give more authority to physicians to delegate to nurses the task of obtaining consent on their behalf. Now, another really objectionable part of the old act were the provisions requiring information to be given to patients both about findings of incapacity and the consequences of findings of incapacity. In the old act, depending on the nature of the treatment, if a finding of incapacity was made, the health practitioner had to notify the patient if the patient was at least 14 years of age, or if the patient was in a psychiatric facility. Well, this was way too complicated, it seemed, and objectionable for philosophical reasons. And so the notice requirements have been substantially, you could say, made less onerous, or you could say watered down. The new requirement is simply that a health practitioner must comply with the guidelines issued by his or her regulatory college about giving notice of a finding of incapacity and about the consequences of the finding. Jim Wilson, the Minister of Health, wrote to every college requiring them to write guidelines and to submit them to the ministry. I'm not aware if any colleges have received any feedback on their guidelines yet. I think it's likely that they will vary from profession to profession. The ministry does have the power to require the college to improve their guidelines. That's a power that the minister has under the Regulated Health Professions Act, arguably. And we'll see if the minister seeks to exercise it if he thinks a particular college's guidelines are very weak. The emergency provisions have been changed somewhat. Understandably, under both acts, if an emergency exists, treatment can be administered to a patient without consent if the patient is incapable and if no substitute decider is available. An emergency is defined, and it means that the individual or the patient is experiencing severe suffering or is at risk of suffering serious bodily harm if the treatment is not administered promptly. In the new act, that's been modified to expand it a bit by saying that the patient is apparently experiencing severe suffering. In addition, under the new act, even if the patient is capable, emergency treatment may be administered without consent if a decision cannot be obtained from that patient because of a communication difficulty, either in the nature of a disability or a language, lack of communication due to different language, as long as there's no reason to believe that the patient doesn't want the treatment. Okay. In both acts, there is an obligation on the health practitioner to continue to search for a substitute decider, or in the case of the I'll call it the non-communicative patient, to seek ways to communicate with the patient. An interesting gap, possibly inadvertent in the CTA, is that it had no provisions that really covered do not resuscitate orders. Now, because do not resuscitate is a non-treatment, you're choosing not to administer treatment, the act did not apply to it because it only spoke to obtaining consent when you chose to administer treatment. Some would think that it's bizarre that you would have to obtain consent to any treatment, no matter how trivial in nature, under the old act, but if a health professional decided not to resuscitate, at least under the act, no consent to treatment would have to be obtained. Under the new Act, DNR, do not resuscitate orders, are dealt with indirectly in the immunity provisions in subsections 29, 3, and 5, where the health practitioner is immune from liability if he or she does not administer treatment in accordance with a treatment plan or in accordance with the patient's wishes. Okay? In fact, it wasn't really a do not resuscitate order, situation, but it almost was, and it speaks to the importance in both acts of the wishes of the patient. A physician received a telephone call from a resident in a hospital. The family was insisting that their dying husband, receive treatment. He was in last stages of cancer and had clearly expressed a wish while he was capable that he did not want any treatment whatsoever. The family was equally adamant that he had to be treated and was threatening to sue all the physicians and the institution if treatment was not promptly administered. It was tough on the physicians to stick to their guns and refuse to administer the treatment. I don't think they exactly knew why they weren't supposed to administer the treatment. They felt bound in an ethical sense by the wishes clearly expressed by the patient, but fortunately they were backed by the law as well. I mentioned the admission to long-term care facilities. That appears in Part 3 of the new Act, and again, there's the parallel system of substitute decision-making regarding admission to homes for the aged, nursing homes, and other not yet prescribed facilities. The system can be resorted to if the patient's consent to the admission is required by law. There's an interesting parallel to emergency treatment in Part 3, and that is crisis admission. If a person is assessed by an evaluator as incapable with respect to with admission, the person may be admitted if the admitting person is of the opinion that the incapable person requires immediate admission because of a crisis, and it's not reasonably possible to obtain an immediate consent or refusal. There's one important difference, though. Even if there is an appeal to the Consent and Capacity Board brought by the person, which under the treatment part of the Act would prevent the start of the treatment, the person can still be admitted to the residential facility for a period not exceeding 90 days. So even if you appeal your admission, they can still put you in this home for up to 90 days. Okay. Quite a few of the provisions relating to Consent and Capacity Board appeals and reviews have been amended. The system has been somewhat expanded to provide new remedies in addition to applying the old remedies to the admission and personal assistance services parts of the Act. One important change to note is that if an incapable patient appeals the finding of incapacity or applies to the board to have a representative appointed to make decisions for them, treatment cannot begin. But if the treatment has already started, and they appealed after the start of the treatment, then the health practitioner does not have to discontinue the treatment. Another important, and I think potentially very, very useful provision relates to the appointment of a representative. Under the old Act and the new, either the patient himself or herself or any other person can make an application to the board to have a person appointed as a representative to make treatment decisions. Under the old Act, that was just the treatment decision in question, a specific treatment decision. Under the new Act, a representative can be appointed to make conceivably all treatment decisions on behalf of the patient, which I think makes this a convenient, low-cost way of having a permanent substitute decision maker appointed for a person without the need to have a guardian appointed under the Substitute Decisions Act. So if you have an incapable person who did not appoint an attorney for personal care, and by the time they need a representative appointed, they're not capable of appointing attorney for personal care, An application could be made to the board to have someone appointed there more or less permanent representative to make treatment decisions. Another practical improvement is that once the board has confirmed a decision that a patient is incapable, a reapplication cannot be made without consent until 6 months have elapsed if the treatment is the same or similar. So you're not going to have a revolving door of people going back to the board. What else? There are a number of changes that you should review yourself to make the board operate a little bit more efficiently. For example, there's provisions for use of fax and electronic communications, and reasons are only going to be required if one of the parties requests the reasons for a board decision within 30 days after the end of the hearing. So if you want reasons, you have to ask for them. In conclusion, I would say that most health practitioner groups and institutional groups are happier with the new act than with the old. Hopefully this means that there will be much more implementation of the new act than the old. I also suspect that advocacy groups for disabled groups of patients and others are probably less happy with the new act, largely because of the dilution of the requirements for giving notice and because of the exception for low-risk treatments. One of the lessons of the CTA is that enacting a statute is relatively simple. Getting people to apply it, implement it, is not simple at all. And hopefully the government has learned that if you're writing an act that depends on implementation by real people as opposed to bureaucrats, you have to write an act that will be accepted by the people who implement it. I believe that health professionals and institutions will still require significant amounts of education in order to make the act real, as well as motivation, and certainly sound legal advice if the new act is to make really a difference in all those places where health care and personal assistance services are provided to people. Thank you very much.
Thank you, Linda. This is the time for the break, and perhaps if we can be back in 20 minutes at 11:10. Coffee and stuff is outside the door to the left as it was when you came in. So please return in 20 minutes and we will continue with the program.